both of you to cover if you can. And I know you've touched on some of this, but let's go back again to witnesses and preparing witnesses, and attendee wanting to know your strategies for preparing a nervous witness for testifying at trial. If you could repeat some of what you mentioned previously about, bringing them to the courthouse and the other tactics that you might have to really relax that witness and get them prepared.
Yeah, I mean, I think as we previously mentioned, preparation is really key, especially if it's a very important witness. And so, just in general, I like to have at least two, if not three, prep sessions with the witness, ideally. One that occurs, not too far from the trial date, but with a good amount of time, so that you have a really nervous witness who's weeks in advance, they're really concerned about the testimony. You can kind of have that session with them and go through things with them at that time. And then you have another prep session that's much closer to the trial date, and kind of walking through what their expected testimony will be. And then, conversations that are occurring right before trial, right before they go on. And I think, and John mentioned this, just with respect to if you're going to try to videotape them, but whether you videotape them or not as part of the prep session, doing a trial run, both, on the direct exam side, you're kind of going through the questions that you expect to ask them and figuring out how they would respond, and try to do that as, 1, 2, 3 times if possible. But also cross-examination, whether it's you or another colleague coming in to, try to get them on cross and determine what you expect your opponent to ask on cross, and seeing how they would respond. That's really most important, I think, on cross, having that run through with them.
Yeah, the nervous witness, the fearful witness, I usually just use drugs on them. No, but it can be a problem, and some people, it's like fear of public speaking almost, only it's perhaps worse. I mean, their credibility is being called into question. You got somebody there on the other side who obviously is trying to make them look bad. You got a bunch of strangers sitting there, stony faced, looking at their testimony, and most reasonable people would be nervous.
Right.
I think if you're not, then you get your own sitcom or something. But acknowledge it to that witness. You know what?
Right.
I'm nervous too when I get up there. I'm nervous. Done it for decades. I'm still nervous when I get up there. I'm afraid I'm not going to do it right, or I'm going to make a mistake. And so the comfort is in, as Chris said, in knowing what you're going to say. I mean, you could never talk somebody out of being nervous if they had some doubts as to what was actually going to be happening and what questions they were going to be asked, right? So that preparation of knowing on direct exam, here's the story, and telling it a few times in response to direct exam questions I like to have some other people hear it. To kind of warm up the witness a little bit, because that's what it's going to be like in court. There are other people that are going to hear this. So if we can round up a few people just to listen to it and take you through it, I think that's of great benefit. And then I like, as Chris mentioned, I think it's effective to use another lawyer. Don't do it yourself, to cross-examine your client or your witness. It creates too many strange vibes, I think, if you become the nasty cross-examiner, but hey, you're my client. So find somebody that's a stranger, because that's what it's going to look like to your client, and somebody that can put them through, 15, 20, 30 minutes maybe of some tough questions.
Yeah. And I've had and sometimes it's just acknowledging that what they're doing, even when they're on the stand, is nerve-wracking. Sometimes, I have a witness who says that, oh, she just feels really nervous about today, or has anxiety, and sometimes that brings empathy to from the jury, that they understand that this is not easy, and so kind of acknowledging that this is not an easy process helps that. And to the counter, if you have a witness who's like too overconfident, and sometimes you get into this with experts. I had an expert who was very full of himself, very overconfident, and just went on and on in terms when I was asking questions about his background and all of his knowledge. And I had juries, when I was pulling them afterwards, I just did not like that expert, and I didn't listen to a word he said because I felt he was really obnoxious, right? So you have, it's like a middle ground where you don't want to be someone who's completely overconfident, because it really turns jurors off, if you're so overconfident that it feels like this is just not a big deal.
Yeah, just real quick, I think on the expert side, that's where it comes up the most, because they are overconfident. They believe they know more about this than anybody else in the courtroom, that they're smarter than the other expert, and they get paid handsomely to do it, and they're going to put on their dog and pony show.